Thanks to those of you who are joining us today for our Know Your First Amendment Rights webinar. We will be starting in 1 minute. 1 minute to give people a chance to sign on and work out all of those logistical issues. So we'll be starting at 11:02 or 2:02, depending on where you are. Thanks. Welcome to all of you. My name is Hadar Harris, and I am the newly installed Executive Director of the Student Press Law Center. Welcome to our first webinar of the school year. It's a year of new beginnings, and many of you are new journalists, new editors, new advisors, and for me, this is new too. I started as the Executive Director of the Student Press Law Center less than 3 weeks ago. So this is the beginning of many new things, and I couldn't be more happy to be here. I want to spend a minute introducing myself to you. It looks like we're going to try to change the screen for a second to get everybody on board. This is a new, as we talk about new things, this is a new experience for us, trying this webinar, linking together with all of you, trying to answer some questions is a new experience. So as we go through this, please bear with us if we may have some technical difficulties. I know you're seeing right now a beautiful vision of our logo. And in a minute, you're going to see pictures of me and our primary speaker today, Mike Hiestand. But I'm going to keep talking as we work out the technical glitches. I want to introduce myself to you. You'll see my face in a minute. I come to this work as an activist and as a human rights attorney. I was on the school paper and on the yearbook staff in high school. But then after I went to college and law school, I went on to live and work in over 25 countries around the world. I worked on issues of civil and political rights, including freedom of expression, gender equality, and the fight against discrimination as a human rights attorney. But I come to SPLC now with a deep belief in the power and the possibility of student journalism, of the need to enable students to speak truth to power, and the vital importance of ensuring that young people find and use their voice to document and engage on issues of civic importance. You're the front line in free press and the next generation of journalists, and it is my privilege to join SPLC to work with you to ensure that your voices are heard. As you know, SPLC has a long history of supporting and defending the student press in the United States. Founded in 1974, we're the only organization providing free legal help to student journalists and their advisors on issues related to things like censorship or copyright or digital rights, freedom of information, among so many other things. The things that we deal with are interesting and cutting edge, and today you're going to hear about some of our war stories and some of the ways in which we have and we can help you as you maneuver your way through the school year. We're going to spend the next 40 minutes, okay, actually now more like 35 minutes, talking about some of the greatest challenges you might encounter as the school year starts, focusing on 3 main issues that have been at the forefront of calls and inquiries that have come to our legal hotline. And that hotline's definitely been heating up as the school year has gotten back in session. This is the first of what we hope will be periodic webinars on relevant and exciting topics that can help you as you do your work this year. If you have topics to suggest or speakers to recommend, or you can tweet them to me throughout the webinar or later. So at this point, I want to introduce a man who encapsulates everything that SPLC is. We're so excited to have Mike Hiestand. on the line with us today. He staffs our hotline, but Mike is really part of the heart and soul of SPLC, how to protect your student press rights today. Mike's one of the premier national experts in student media law. His affiliation with SPLC started in 1989, just after the very problematic Hazelwood decision came down from the Supreme Court, which impacts and limits student press rights. He served as an intern, he served as SPLC's first legal fellow, and he's been a longtime staff attorney for us. Today, he's the man behind the hotline. He answers your questions, and he's available to any and all of you when you have legal questions or if you find yourself in a bind. We have him. I want to remind you that if you have questions or comments, you can tweet them to us at SPLC. And at this point, Mike, I want to turn it over to you.
All right. Well, thank you, Hadar. And yeah, this is very exciting. He said, I've been around since 1989. This is the first one of these I think that we've done, at least the first one that I've done. So thank you. So what I'd like to do this morning, kind of three main things. The first thing Hadar has kind of touched on already is just kind of introduce ourselves and the SPLC and some of our services, and just let you know, for those of you that aren't familiar with the SPLC, kind of what our mission is, and that we are available to you. And I'll show you in just a little bit kind of the process for getting in touch with us, and just some of the resources on our website. The other thing that I want to talk about is just kind of to hit on the top three sorts of reasons that people contact the SPLC. Ever since I started in 1989, the number one reason every year in and out has been censorship. And so we're going to talk a little about censorship, what your rights are, and just what some of the resources that we can offer to you that you might want to take a peek at. The second topic we're going to talk about is copyright, and copyright is skyrocketed. I mean, copyright used to be fairly low down the list on the reasons that people called us, but ever since the internet has come along, and I was there when it was born at the SPLC, copyright has really jumped up. So that's, I think it's pretty consistently the number two reason people call us. The third thing that we're going to talk about on fairly quickly is freedom of information law and access to records, public documents, public meetings. FOI law and libel law and invasion of privacy law kind of battle it out, it seems, for the number three position. But we're going to talk about just some of the resources that we have available when you're looking to get access to public records specifically today. The third thing that we're going to talk about, that my goal here today, is to tell you two things that you need to do right now. A few years back, I put out a back-to-school checklist that talked about just some of the things that I thought it was a good idea to tackle at the beginning of every school year. And on the list, and certainly I still suggest this, is things like inviting your administrators, your principal, down to the newsroom. When you don't have a problem, it's great to have them, come see what you're doing, see just how serious you are about your craft. Invite the local editor from the local newspaper in, or the local TV station. Again, it's great to kind of start these relationships when the relationship is good, when there's no big problem that you're trying to deal with, and just to have them available and have them see you as a person, and you see them, and start that relationship. So we'll start, though, with censorship. And censorship, as I said, is the number one reason people have always contacted us at the Student Press Law Center. It's unfortunate that the law is as complex sometimes as it is, and so we're not going to have as much time as I really would like to have, or as I need to have, to really go into the nitty-gritty of what sort of rights that you have as a high school student journalist in this country. But one of the things that I will say, Hadar talked about the 1988 Supreme Court decision in Hazelwood. And Hazelwood really changed everything for student journalists in this country. It really drastically altered much of the law that affected high school student journalists. Prior to Hazelwood, hopefully many of you guys have already heard about this, there was a case called the Tinker case, Tinker v. Des Moines, which involved a young 13-year-old Mary Beth Tinker who wore a black armband to school to protest the Vietnam War and to mourn those that had been killed in the war. And her case worked its way up to the Supreme Court, and in 1969, the Supreme Court handed down a decision which was really, a lot of people are surprised by this, but it was the first time really that the Supreme Court had directly addressed the question of what sort of free expression, what sort of First Amendment rights do students have when they're in school. The court had kind of played around the edges of that for a while, but this was really the first opportunity they had to address that question. And in Mary Beth's case, in the Tinker case, they ruled that Mary Beth had the right to wear an armband to school, and they set up what's known as the Tinker Standard. The Tinker Standard says that you have the right to speak out in school. You're covered by the First Amendment as long as you do so lawfully, so you don't have the right to engage in libel or invasion of privacy. You can't commit copyright infringement, obscenity, that sort of thing. The things that all of us have to be worried about. And then the second sort of prong that they added for the Tinker Standard is that you also don't have the right to engage in speech that creates a serious physical disruption, so a material and substantial disruption of school activities. But if you, under Tinker, if you are engaged in lawful speech, and as long as your speech isn't disruptive, under Tinker, you had the right to engage in that speech in school. In 1988, that changed for high school for high school students engaged in what we call school-sponsored speech, including specifically student media that are put together as part of a class where you have an advisor, where there's some funding for the student newspaper. Under Hazelwood, the laws changed significantly, and basically the court handed back to school officials a lot of the authority that Tinker had said, you know what, you need to give students some breathing room. They gave that authority back to school officials and really allowed for much more censorship. And we at the Student Press Law Center saw an explosion. I mean, calls to our group, to the center, you know, just went up, I think, about 5 times in just a few short years. So, so it was a really big deal. Now, one of the things, so I'm going to show you on our website here. Like I said, I don't have a lot of time to talk about Hazelwood, but you do need to know about it. So let's see if we can get to our website. Like Hadar said, this is all brand new. So SPLC.org is our website. Just want to make sure you guys are seeing that now. Yes, I guess you are. So what you want to do when you get to our website, first of all, let me just show you how to get in touch with us if you can't find the information on the website that you need. So the first thing I want to show you is just our legal help page here. Under legal help, go to ask for legal help. And one of the ways you get in touch with us is either scheduling a phone call. It's nice and easy, very simple system there, or send us an email. Email is better for sort of non-urgent questions. So we have, you know, up to 5 business days. We tell you to get back to you. We usually do a lot better than that, but it is for non-urgent emails. If you have something more urgent, probably a phone call. And if it's really, really urgent, definitely call somebody in our Washington, D.C. office and talk to them directly. So that's how you get in touch with us. As far as like kind of do-it-yourself sort of help, one of the things that we have here, so under the legal guide thing, you'll go to the Press Freedom and Censorship, and under high school here. One of the wonderful guides that we've put together over the years is our guide to Hazelwood High School, Hazelwood School District Kohlmeyer Guide, which really does go into a lot more information just about what sort of rights you actually do have, what sort of restrictions Hazelwood imposes, or what sort of restrictions Hazelwood allows. And it's important, I think, at the very beginning of the year to get a good sense for that. One of the first things I will do, though, when you call is I'm going to ask you where you're calling from, because after Hazelwood, because Hazelwood really did sort of change the balance between student rights and school authority. A number of states said that, no, we don't want to do that. We actually think that Hazelwood goes too far. We want to give back to our students some of the legal protections that they had prior to Hazelwood. Basically, we want to give them back their Tinker Standard sort of protections. And so immediately after Hazelwood was passed, we had a number of states, about half a dozen states, that passed what we call student free expression laws. We call them anti-Hazelwood laws sometimes, because that's effectively what they do. They've kind of neutralized the impact of Hazelwood for students in those particular states. So you can see the little map here. And we have a little New Voices tracker. But if you happen to be in one of the states that are in green here, right now there are 13 different states that have actually given back to their students some significant legal protection. So when you call them and ask you where you're from, and if you happen to be from California or Oregon or Illinois or a number of the other states, the information that I have for you is usually going to be good, because these laws really do make a difference. They really do limit the degree of censorship that school officials have. It doesn't give you 100% free reign to do whatever you want. I mean, the laws still are restrictive. I mean, you still can't engage in libel. You can't, publish obscenity in your paper. There are things that reasonable reporters just don't do, and these laws don't give you any particular permission to cross those lines. But again, they do provide significant protection, and so just want you to be aware of that. The other thing that I want to point out here is that Hazelwood only applies to, let me see if I can get back to me. That's not me. We're going to get better at this, I promise. Okay, well, I'm just going to let you keep looking at the screen here. I'll just keep talking because I think. There I am. Okay. Yeah, okay. So, Hazelwood is certainly it's hard to kind of overstate the impact that Hazelwood had on high school student journalism in this country. But its impact is not unlimited. And that's, you'll often hear school officials cite to Hazelwood for pretty much, upholding their right to do anything they want with student media. And that's simply not the case. I mean, there still are some limits that they have to abide by. Their censorship authority is not unlimited. And one of the things where it's particularly important to keep in mind is that Hazelwood only applies to school-sponsored student media. Non-school sponsored student media, which includes a lot of media these days, is not covered by Hazelwood. And that for non-school sponsored student speech, you're still covered by the very protective Tinker standard. So when we're talking about non-school sponsored media, we're talking about things like this. One of the things I like to remind people is that in 1965, when Mary Beth wore her black armband to school, the reason she did that was because, in 1965, that was one of the few sort of speech tools that was available to her. I mean, in 1965, you could, write a letter to the editor, which the editor, had the right to publish or not publish. You could stand up with your placards and your signs and things like that and march around. Or like she did, Mary Beth, you could wear a black armband to school. But your opportunities for engaging in speech were pretty limited. In 2017, obviously, that's changed. Your opportunities to speak out are amazing. I mean, they truly are for people, born when I was. I mean, it really is. It's just kind of mind blowing, the sort of opportunities that are available to you. And so when we're looking at, getting your message out and dealing with censorship when it comes in, it is important to remember that, the First Amendment is not your only source of legal protection. I think that free speech is simply a human right. And if the First Amendment doesn't allow you to engage in free speech within your school, I think you got to remember that you have the right to say what you need to say. I mean, you have to be responsible for everything you say, but you have that right. And things like your smartphone and the internet and everything give you a lot of options. And one of the things we like to do with this SPLC is, is make sure that you use those tools smartly. The last thing you want to do is use them in a way that just creates more problems for you. And so, just remembering that we're available if you have questions that come up about how to do some of these things, we're happy to help. The other thing I want to show you just on censorship before we leave this, and we're going to try going back to our screen here. Okay, I hope we're up. Hadar, can you see my can you see the SPLC website right now?
I see you trying to get to it.
Okay, so let's try to get there.
I mean, yeah, I don't.
Let's try screen share.
We are helped very ably by our publications fellow, Danielle Dietrich, who is sitting behind us all and helping us try to work this out. There we go.
Okay, there we go. All right. So
Danielle, if you want to pipe in and give us some here, feel free to do that. Thank you.
So going back to the legal guides there, one of the things that is available to you too is that we have a fighting censorship checklist after Hazelwood, and also right under our legal help page is a responding to censorship guide. And so one of the things that I will talk with you about when you call us up is just some of the things you can do when a censorship issue comes up. And number one thing on the list here is this reminder to practice good journalism, to actually the best most effective tool against censorship is being able to stand up and proudly defend that work. And so, all the things that you're learning in your journalism classes about, just basic news writing and how to, talk to both sides and to obtain documents when you can, and to do all those, basic journalism 101 things. That is just absolutely critical when you have a censorship fight, because it's easy for administrators to knock down bad journalism and to attack you that way. But if you have a story that you are proud of, that your staff and you have worked hard to get to the place where you're confident in its accuracy and all that good stuff, I can't tell you how much that actually helps. Now, the last thing I want to talk about here is one of I said there were two things that I wanted to make sure that you did right now, and one of those things we're actually gonna cover at the beginning of every school year. I would, like I said, I put out this back to school sort of checklist, and one of the number one things on the checklist was I told folks they needed to have what I called the talk, and the talk was simply this. The talk was just a reminder. It was an opportunity for the advisor at the school to remind the students that, at the end of the day, they are employees of the school, and that as an employee, their ability to do certain things. I mean, if their principal says you need to censor that article, very often it's going to be up to the advisor to censor the article, whether they want to or not. Now, advisors aren't in this business. They don't teach journalism to you to censor. I mean, that's kind of against what they believe in, at least most of them, and it's going to make them lose sleep at night when they have to do things like that. But they are an employee, and sometimes they, as an employee, you have to do things that you don't want to. You, as students, on the other hand, are in a different position. You are not employees, and the principal doesn't have the same sort of authority over you that he has over your teacher. And so, at the beginning of the year, and we're doing it right now, just a reminder to you that your advisor is, an employee, and it's really up to you when you have a censorship battle to take the lead. It's up to students to own. It's the student newspaper. And it's up to students, I think, to own that, and if there is a censorship fight to be had, it needs to be waged by the students. You're the ones that need to go in and set the meetings with the principal. You're the ones that need to go, as you're going through the checklist and it talks about contacting local media to let them know what's going on. You're the ones that need to do that. Your advisor can't do that. They shouldn't do that. The last thing you want to do is have your sole sort of supporter on the staff get fired. And so one of the things I pass on to student media advisors, and I suggest that all students as well read, is this kind of student tip sheet for me, student media advisors, which just kind of explains what your role is. And it has a few other things here, but that's the main thing I want to convey. This is the talk. You guys are in charge. You're the ones that really need to take responsibility. All right. So I'm going to come back. There we are. All right. And we're in pretty good shape time-wise here. Next thing we're going to get to is copyright. And as I said, there were two things on my little back-to-school list, and one of them actually has to do with copyright, so we'll take care of that as well. But copyright, it's really interesting for student media in particular, because there is a real issue that comes up sometimes with student media about who owns the copyright. You guys are creators. You guys are, putting together stories and taking photos and doing artwork and design work, and all you're putting together work that actually it's copyrighted. The minute that you guys are creating it, it is protected by copyright. But the question sometimes is, who owns the copyright? Is it the school? Is it the students? If it is the students, and it is, and I'll talk about that in just a sec, how exactly are those rights apportioned? Because the student media, your student newspaper or yearbook, obviously needs to use your work. And so it's because the law is not quite as clear for students as it is for like a traditional employee. What we suggest is that you always put together a copyright agreement. We're going to go back to our screen here. And so just down under our legal guides, under copyright there, we actually have a model copyright agreement. And what this does, it's our attempt to come up with a kind of a fair balance between the rights of students who own their copyrights and the need of the media organizations they work with to actually use their work in a fair way. So the copyright agreement says specifically, it acknowledges that under existing law right now, most student journalists, unless you're being paid and treated like any other normal school employee, which is not typically the case at a high school, that you own the copyright. Everything that you create, from the minute that you create it, you, the student, owns that copyright. And what our model agreement does is it acknowledges that, but then says you are providing a license to the student, to your newspaper, your yearbook, or your online publication. You're providing a license to them to use the work for exclusively. Our agreement actually says they have exclusive rights for 3 months, but then they can use it in particular ways without getting your permission going forward. At the same time, you do retain the copyright yourself. So if you want to go out and use your photos and sell them or do whatever you want with them, you also own, you retain that copyright. You're simply providing a license to your media organization to use it for their purposes. It's important to get this together at the beginning of the year because if you don't, problems can arise at the end of the year if you've operated without any sort of agreement. It's just one of those kind of housekeeping things that I always think it's a great thing to take care of. So as far as copyright goes, the substances of copyright law, the idea is, the general rule is, if you didn't create it yourself, if you didn't create the work yourself, so if you didn't take the photo or if you didn't write the story yourself, you have to get actual permission before you use it. Now, there is a very important exception to this called the fair use exception, which unfortunately I don't think we're going to have a lot of time to get to today. But the general rule is, and if you don't cross this general rule, you're not going to get into trouble. The general rule is, if you didn't create the work yourself, you must get actual permission to use it. Now, there are some, in addition to the fair use exception, there are some exceptions. There are actually now more and more copyright safe materials that you can now use. And we actually put together a list of copyright safe materials. Now, what a copyright safe material is, so under traditional copyright law, when you look at the copyright notice, it says, typically there's a little copyright symbol and the date and the copyright owner, and sometimes it says something like all rights reserved. There are new sort of models in place that modify the traditional copyright law model. The one that most everybody knows about is Creative Commons. And under a Creative Commons license, if somebody takes a photo and instead of copyrighting that photo, they put it under a Creative Commons license, what they're saying is that instead of all rights reserved, they're saying some rights reserved. And very often the rights that they're reserving are limited to in a way that permits you to use it for your purposes. The most common sorts of licenses that exist under Creative Commons are the photo owner, for example, will say that you have the right to use my photo in a nonprofit sort of way, which for student media is great. You have the right to use it in a nonprofit way as long as you attribute it to me. That's a very common Creative Commons sort of license provision. It's important when you're using work from a Creative Commons source, though, to look at the specific license because they do vary. Those are two common sort of provisions in the Creative Commons law, but sometimes they have additional ones, and you'll need to be aware of those. We've put together here a list of sites and places where you can go where Creative Commons or some other copyright scheme is in place that allows you to use these works. It allows you to kind of go around the traditional copyright rule that says you have to get permission first. These sites allow you to use this work without permission as long as you are in compliance with the Creative Commons license. Another source, and down here actually is some of the Fatalia. Pixabay is one of my favorite sort of Creative Commons places. They have beautiful pictures and all sorts of things that are available to use for free and typically without getting any sort of permission. The other thing that I'll point out real quick here is there is some work that is what we call in the public domain. And a very typical type of public domain work is anything that's created by the federal government is actually available to use without permission. If it's something that's created by a federal government employee, just copyright law says that you can't copyright that. It's in the public domain, and when it's in the public domain, you can use it. So one of the things so you see the White House, any photos taken by the White House photographer or NASA. NASA has some beautiful photos, especially like for yearbooks and things like that. You can use amazing sort of stuff. But another great thing is that you might want to look at right now is like the FEMA site. So the FEMA Media Library. You guys are doing stories and you browse, they have 45,000 different photos, I guess, that are available right now. But if you're doing a story on, some of the hurricanes, here is a photo on the FEMA website. It looks like it was taken yesterday. It's FEMA down there helping Hurricane Irma survivors. But this photo is one that you can put in your newspaper, put it in the current, the year in review section of your yearbook if you need to. And you don't need anybody's permission to do so. You obviously want to credit it, make sure that it is credited appropriately to FEMA, the FEMA photographer, but no permission is necessary. So like tons and tons of pretty high quality photos that are available. All right. The last thing I want to talk about before I turn it back over to Hadar here is freedom of information. And freedom of information is FOI questions, like I said, probably about the number 3 reason people call. And the only thing I want to talk about there is just how simple it is to use these open records laws. Basically, an open record, every state has an open records law, and an open records law in a state, they pretty much all say the same thing. It just says if a record is created by a government official, by a government agency, the presumption is that that record is open. The law says that the presumption is that records created by government officials are open and available for inspection, available for copying, available for use. Every law, though, does has certain exemptions in it. So the presumption is that the record is open unless the law lists particular exemptions in the law. And they can point to a particular exemption as allowing them to withhold the information. The thing I want to point out, though, on our website, so under legal help, you go and we have the coolest thing ever. This started 20 years ago in 1997. We actually put this together, and this is the only one at the time. Basically, it's a public records letter generator. It's an automated system. If there is a particular record held by a government official, so the school board, you want to get the school board budget, or you want to perhaps get a copy of the latest health department inspection of your cafeteria. Those are records that will be available, and all you have to do is ask for them. Typically, you can ask for them, just like verbally go and ask for these records, and that should be enough. If for whatever reason they don't provide them to you simply with a verbal request, you can use our very cool open records letter generator to create an official letter with all the regular the cites for your state law and all the different provisions in there, and you print it out and you send it to them. And once they get this letter, they have two choices. They either have to provide you with the record that you're looking for, or they have to point out what specific exemption in the law allows them to deny your request. Very simple. And so all you need to do in order to fill out the records generator is just kind of have a sense for what you're looking for. You don't have to actually have document numbers, specific document numbers or document titles. Just a very, a reasonable description of what it is you're looking for is sufficient in order to make the request. In addition to that, you just simply need to know who it is that you're going to send the request to. And basically, you find out where is the record physically being kept. Whoever is physically holding onto that record is supposed to be the one to respond to a public records request. In some cases, like at a large university or something like that, there may be a public information officer that's been delegated that responsibility, and your request should go to them. But initially, if you're looking for a copy of the health inspection, go to the health department, get the name of the head of the health department, get their address. You can get all that stuff online, and simply say, I'm looking for a copy of the most recent health department inspection of our cafeteria, and send it off. And by gosh, I guarantee you will probably have a copy of your health inspection within not too long. So that's about it. I think that's all I have time for right now. Some quick hits here. I'm going to turn it back over to Hadar.
And we will wind it up. Thank you, Mike. There was a lot in that presentation. We touched on the top 3 things that you want to know about the top 3 issues facing you today: censorship, copyright, and the right to information. As you could see, there are so many resources on the SPLC website, and it's not just about the resources on the website, it's about the resources in the mind and body of Mike Hiestand, who is a walking encyclopedia, not only of knowledge, but really about tactics and strategies to address some of these issues as they may come up in your work as journalists over the course of the year. Also, we're available to assist advisors as well, which is really very important. As Mike said, there are different standards in terms of who can do what and what rights lay. But we're well versed in how to maneuver through all of that. So I would, point you to so many resources on the website, even more in discussion about the issues that come to us, that come up. Please use us, call us, follow us on social media, send us your thoughts and your ideas. As we wind up right now, conscious of our time, I want to say a big thank you to Danielle Dietrich, SPLC's publication fellow, for her hard work in setting up this first Google Hangout of our new era, and the first of what I hope will be many. Also to Diana Mitsu-Kloss, SPLC's Director of Engagement, for her support and her vision and her enthusiasm when I came in a couple weeks ago and said, hey, let's do this Google Hangout and see what happens as we move this and so many other things ahead. We're a small but mighty team, and we look forward to working with all of you in the year ahead. There is so much to do, but we look forward to being sure that your voices are heard. Follow us on Facebook, tweet at us at SPLC, look for us on social media, call our hotline, access our website. We look forward to seeing you in the new school year. All the best. Thanks so much for joining us. Bye, Mike.